Good morning, Alex and friends. I'm Grace. Today is Wednesday, March 25th, 2026, and you're listening to Alex's News. It is going to be a hot one in Riverside today, with a high of 90.2 degrees and a low of 67.3 degrees. So please make sure to stay cool and drink plenty of water if you find yourself outside. Today, we will look into the legal strategy a jury in New Mexico utilized to hold Meta accountable for their actions. We are also examining the role a private prison is currently playing in overseeing investigations into reports of sexual assault. Beyond these major stories, we have a variety of other headlines to cover on today's episode. There is a lot to get to on Alex's News. Stay tuned. We start this morning with a verdict that could reshape how big tech operates. Yesterday in Santa Fe, a New Mexico jury found Meta liable for harming children and hiding the scale of child sexual exploitation on its platforms. The penalty came in at $375 million. Ethan covers technology and policy for us. Ethan, how significant is this?
This is genuinely historic, Grace. It's one of the first times a jury has looked inside a major social media company and said, "You knowingly hurt kids." NPR and PBS NewsHour both reported that the jury found Meta engaged in unconscionable and deceptive trade practices under New Mexico's Unfair Practices Act. The core finding was that Meta prioritized advertising revenue over the safety of its youngest users. Legal experts are already calling it a watershed moment for the entire industry.
Walk us through the trial itself. How long did this take to unfold?
Nearly 7 weeks of testimony and evidence in a Santa Fe courtroom. New Mexico Attorney General Raul Torres brought the case, and his team presented a mountain of internal meta-documents alongside some really dramatic witness testimony. The jury calculated the fine based on thousands of individual violations of state law. According to both ABC7 Chicago and the Associated Press, jurors applied the maximum penalty of $5,000 per violation to reach that $375 million figure.
That's a big number. But Torres originally wanted $2 billion, right?
He did. The final amount is less than 1/5 of what the state sought. And honestly, Wall Street barely flinched. Meta is valued at roughly $1.5 trillion, and the stock actually rose 5% in after-hours trading yesterday. Investors clearly see this as manageable financially. But advocacy groups like Parents SOS, a coalition of families who've lost children to social media harms, and the Tech Oversight Project argue the real power here is the legal precedent. One spokesperson said Meta's, quote, "house of cards is beginning to fall," end quote.
So the money itself isn't the story. What is?
It's what came out during the trial. Probably the most devastating piece of evidence was an internal Meta presentation from 2021 that was unsealed during litigation. It estimated that roughly 100,000 children are sexually harassed every single day on Facebook and Instagram. As techpolicy.press reported, that number came from Meta's own internal surveys, not from its automated safety systems. The company had been publicly claiming its AI caught 99% of exploitation content, but its own data showed 13% of 13 to 15-year-olds received unwanted sexual advances within just 1 week.
100,000 children a day. How did Meta even arrive at that number internally?
Through something called Bad Emotional Experience Feedback Surveys, which employees apparently abbreviated as BEEF. These were direct surveys of young users, not automated flags or content reports. And the harassment wasn't limited to predatory adults contacting kids. It covered a broader range of what Meta internally labeled problematic interactions. The gap between what the company knew from these surveys and what it told the public became a central theme for the prosecution. It painted a picture of a company that understood the scope of harm but chose not to act on it in any meaningful way.
There was also undercover work involved in the case, wasn't there?
Yes, and it was striking. New Mexico state agents testified that they posed as children on Meta's platforms. They said they were targeted by adult predators with explicit solicitations almost immediately. That testimony landed hard with jurors because it made the danger tangible and personal. On top of that, the jury reviewed correspondence showing that CEO Mark Zuckerberg and Instagram head Adam Mosseri were personally aware of safety risks and what the company called problematic use, but didn't enforce meaningful age verification or address what prosecutors described as addictive loops built into the platforms.
Was there whistleblower testimony too?
There was. Former Meta engineering director Arturo Bashir took the stand and explained that the company's internal definitions of violative content were far narrower than the actual harm children experienced. In practice, that meant Meta's automated safety tools were filtering for a very specific kind of content while ignoring a much broader universe of harmful interactions. Bashir essentially told jurors that the system was designed to look effective on paper while leaving kids exposed in reality.
Now, Meta has long relied on Section 230 of the Communications Decency Act as a legal shield. How did New Mexico get around that?
That's really the legal breakthrough here. According to analysis from mofo.com and legalnews.com, the prosecution reframed the entire case as product liability rather than a content moderation dispute. Instead of arguing that Meta failed to remove harmful posts, which Section 230 would likely protect, the state argued that Meta's platforms are defective products by design. The harm came from engineering choices like infinite scrolling, notification timing, and intermittent variable rewards, features specifically designed to bypass the neurological self-regulation of children. By focusing on algorithmic curation, meaning actively pushing content, rather than simply hosting it, the state established that Meta had a duty of care it failed to uphold.
That's a clever legal strategy. But what about the science? Is there consensus that social media actually causes mental health harm in kids?
It depends on who you ask, and the jury found legal liability even though the scientific community is still debating causality. Researchers like Jonathan Haidt at NYU argue there's a growing causal consensus, and he points to studies where digital detoxes significantly reduced clinical depression in young people. But as the Independent and Johns Hopkins researchers have reported, many scientists see social media as more of a risk multiplier than a sole cause. They point to economic instability, climate anxiety, and lingering isolation from the pandemic years of 2020 through 2022 as primary drivers of teen distress. Meta leaned heavily on that argument throughout the trial.
So Meta's defense was essentially, don't blame us for a generation's mental health struggles.
Exactly. They maintained they can't be held responsible for broad mental health trends affecting an entire generation. But the jury clearly found that argument unconvincing, at least when weighed against the internal documents showing the company knew its products were causing specific, measurable harm, and chose profits over fixes. That disconnect between what Meta knew and what it did was ultimately what the jury couldn't look past.
Let's zoom out. There's another trial happening right now in California, isn't there?
There is, and the timing is remarkable. As of today, March 25th, a jury in Los Angeles Superior Court is on its 9th day of deliberations in a case called KGM versus Meta and YouTube. According to the LA Times, that jury reached an impasse earlier this week. Judge Carolyn B. Kuhl has issued what's known as a dynamite charge, essentially urging jurors to keep working to avoid a partial mistrial. The New Mexico verdict landing right in the middle of those deliberations could absolutely influence how that jury thinks about the issues.
And there's a bigger federal case looming too?
A massive one. Federal multi-district litigation known as MDL 3047 involves more than 40 state attorneys general and is set for trial in June of this year. The $375 million fine from Santa Fe now serves as an informal financial floor for thousands of pending cases. Legal analysts expect it to put enormous pressure on Meta to consider settlements rather than risk even larger verdicts down the road.
So this isn't over even in New Mexico. What happens next in Santa Fe?
In May, Chief Judge Brian Beachside will preside over a second phase, a bench trial without a jury, to determine whether Meta's platforms constitute a public nuisance. If he rules against the company, Meta could be legally required to implement sweeping changes specifically in New Mexico. We're talking mandatory age verification tools to block users under 13, algorithmic restructuring to disable features like infinite scroll and autoplay for minors, and potentially billions in additional payments to fund statewide mental health screenings, sextortion trauma counseling in schools, and expanded law enforcement units targeting online predators.
Has Meta said anything about appealing?
They've already announced plans to appeal. The company claims the state cherry-picked documents to build a misleading narrative. But for advocacy groups and the families who were represented in that courtroom, yesterday's verdict stands as the first time a jury of ordinary people looked at Meta's inner workings and declared its practices unconscionable. Whatever happens on appeal, that finding is now part of the public record, and it's going to shape every tech accountability case that follows.
Ethan, thank you for breaking all of that down for us this morning.
Happy to be here, Grace.
We've got one more story to get to this morning, and it's a troubling one out of San Diego County. A months-long investigation has revealed that a private prison company has essentially been deciding which rape allegations get investigated by law enforcement. Chloe has been following this closely. Chloe, walk us through what's happening here.
So this centers on the Otay Mesa Detention Center, which is an immigration detention facility run by CoreCivic, the nation's largest for-profit prison corporation. Cal Matters and CBS 8 have uncovered that the San Diego County Sheriff's Department basically handed over its investigative authority to the facility's administrators. Under a memorandum of understanding signed back in 2020, the facility's warden is the one who decides whether a rape allegation ever reaches law enforcement. If the warden doesn't specifically request the sheriff's involvement, no criminal investigation happens.
Wait, so a private company employee is the gatekeeper for criminal investigations?
That's exactly what's happening, and the numbers are alarming. According to 911 dispatch logs obtained by Cal Matters, at least 7 reported rapes and 4 attempted sexual assaults occurred at the facility in 2025. Not a single one of those led to a criminal investigation by the Sheriff's Department. Because CoreCivic never requested intervention, none of those cases were ever forwarded to the San Diego County District Attorney either. So we're looking at 0 criminal charges filed across all of those incidents.
And what is CoreCivic saying about all of this?
CoreCivic says it has a, quote, zero tolerance policy, end quote, and that it conducts administrative investigations into every allegation. But here's the critical distinction that KPBS and other outlets have really hammered on. CoreCivic is a private corporation, not a law enforcement agency. It doesn't have the legal authority to conduct criminal investigations. The company claims it refers potentially criminal matters to authorities, but the records tell a different story entirely.
So who signed off on this arrangement in the first place?
The Memorandum of Understanding was signed in 2020 by former San Diego County Sheriff Bill Gore and CoreCivic. An MOU is basically a formal agreement outlining how 2 parties intend to work together. They're common in government, but this one created what critics call a dangerous accountability loophole. It gave a civilian warden, currently a man named Christopher LaRose, sole authority over whether serious crimes get a real investigation.
And the current sheriff is standing by it?
She is. Current Sheriff Kelly Martinez defended the agreement just yesterday at a public forum called the Truth Act Forum. She offered a few justifications, according to the Los Angeles Times. She said her department lacks the staff capacity to investigate every criminal allegation at federal facilities the county doesn't own. She also argued that investigating facilities tied to the federal government is a, quote, difficult ask, end quote. And she made a pretty striking claim that without this MOU, CoreCivic might stop reporting incidents to the sheriff altogether.
That last part sounds like she's saying the agreement is better than nothing.
That's essentially her argument, but legal experts aren't buying it. Reporting by iNewsSource and The Coast News points out that under California Government Code sections 26,600 through 26,602, the sheriff is the chief law enforcement officer of the county with a statutory duty to investigate public offenses. And here's a detail that really undercuts the jurisdictional argument. CoreCivic actually purchased the land where Otay Mesa sits back in 2010. It's privately owned land, which means the sheriff maintains primary criminal jurisdiction there without question.
So there could be actual legal violations in this arrangement?
Multiple ones, potentially. Start with the Federal Prison Rape Elimination Act, known as PREA. Those standards specifically require that all allegations of sexual abuse be promptly referred to an agency with legal authority to conduct criminal investigations. Having a private warden screen what's, quote, credible, end quote, before deciding whether to report arguably violates the entire framework of that law. CalMatters found that PREA-related calls from the facility actually increased from 14 in 2024 to 21 in 2025, even as investigations stayed at 0.
Are there state laws being potentially violated too?
Yes, and this is important. California Penal Code, Section 11,160, requires medical staff to report suspected sexual assault to law enforcement immediately. That's a mandatory reporting obligation that exists regardless of any agreement between a sheriff and a private contractor. On top of that, California legal principles generally prohibit public officials from contractually delegating core police powers to private, for-profit entities. That's known as the non-delegation doctrine, and critics say this MOU runs right into it.
Has there been any pushback from local officials?
Significant pushback. San Diego County Board of Supervisors Chair Tara Lawson-Remer has called the situation, quote, troubling, end quote. She said she has, quote, no confidence, end quote, in a private company's ability to investigate itself, according to Yahoo News. Advocacy groups like the California Collaborative for Immigrant Justice have also spoken out forcefully. They point out that Otay Mesa houses nearly 1,500 detainees, most of whom haven't been convicted of any crime and are simply awaiting immigration hearings.
So these are people who are essentially in civil detention, not serving criminal sentences.
Exactly, and that makes the lack of protection even more troubling to advocates. These are individuals in government custody who have a constitutional right to safety. When the entity responsible for their care is also the entity deciding whether crimes against them get investigated, you've got a fundamental conflict of interest. That's the core problem critics keep coming back to.
Has anyone tried to get more information through public records requests?
Journalists have tried, and they've hit a wall. When reporters filed Public Records Act requests for 911 audio and dispatch logs, the Sheriff's Department refused to release them. The department claimed the records were part of active law enforcement investigations, but here's the contradiction that CalMatters and CBS 8 flagged immediately. The department was simultaneously saying it wasn't investigating these cases because CoreCivic hadn't requested its involvement. You can't have it both ways, claiming records are part of active investigations while also admitting no investigations are underway.
That's a pretty glaring contradiction. What's being done at the state and federal level to address this?
There's a lot of movement right now. 15 days ago, on March 10th, the San Diego County Board of Supervisors filed a federal lawsuit against the Department of Homeland Security, ICE, and CoreCivic. That lawsuit seeks to enforce SB 1132, a 2024 state law that grants counties the power to conduct public health inspections of private detention facilities. It's a significant legal escalation that could open the door to greater oversight.
And is the state legislature getting involved?
Two major bills are working their way through Sacramento right now. SB 995, called the Masuma-Khan Justice Act, would require private detention facilities to obtain state operating licenses. Then there's SB 942, which goes directly at the problem we've been discussing. It would mandate that local law enforcement, not facility wardens, lead all criminal investigations into sexual violence at these sites. Either bill could fundamentally change the dynamic if signed into law.
Is this kind of arrangement unique to Otay Mesa?
Unfortunately, no King 5 News and other outlets have reported similar patterns at other facilities across the West Coast. The Adelanto Detention Facility in California and the Northwest ICE Processing Center in Tacoma, Washington, have both seen local police defer to private operators in similar ways. So this appears to be a broader systemic issue, not just one rogue agreement in San Diego County.
And as of this morning, the original agreement is still in place?
It is. Despite all the political pressure, the investigative reporting, and the federal lawsuit, that 2020 MOU remains in effect today. Sheriff Martinez continues to assert her independent authority as an elected official. She maintains that the Board of Supervisors cannot dictate her department's investigative policies, which sets up a real standoff between the county's elected leaders and its top law enforcement officer.
Chloe, this is really important reporting. Thank you for breaking it all down for us this morning.
Thanks, Grace.
Here are some other headlines. We start with a grounding report from the National Transportation Safety Board regarding Sunday's fatal collision at LaGuardia. It appears the airport's safety system failed to spark an alert because the Port Authority fire truck involved was not equipped with a transponder. Air Canada Flight 8646, carrying 76 people from Montreal, struck the rescue vehicle on runway 4 after a controller cleared the truck to cross just 12 seconds before the jet touched down. This tragic runway encounter claimed the lives of pilots Mackenzie Gunther and Antoine Forrest and injured over 40 others. Tower audio captured a distraught controller admitting that they messed up, and Chair Jennifer Homendy is now investigating if simultaneous emergencies and staffing levels left the two controllers on duty feeling short-handed. This accident has severely hampered operations, with runway 4 closed until at least Friday, March 28th. Leading to a 25% flight cancellation rate and average delays exceeding 4 hours. Moving across the globe, Israel's Defense Minister Israel Katz announced on Tuesday, March 24, 2026, that the military is looking to go with the flow, expanding operations to occupy southern Lebanon up to the Litani River. This defensive buffer zone represents a long-term occupation of nearly 10% of Lebanese territory. To support this major expansion, the government is expected to call up approximately 400,000 reservists. The military has already begun burning bridges, literally, to isolate frontline positions and deny logistical support. This move marks a significant escalation since the conflict began on March 2nd, threatening a protracted guerrilla war and a humanitarian crisis, with over 1 million people already displaced. In the Caribbean, things are looking a bit dim as Cuba's national electric grid remains in a state of total collapse following the third island-wide blackout this month. While Prime Minister Manuel Marrero Cruz announced a partial restoration, life on March 25th is at a near total halt, with daily outages lasting up to 20 hours. Officials attribute the cascading failure to a unit breakdown at the Nuevitas plant and a critical lack of fuel. President Miguel Diaz-Canel blames a de facto United States oil blockade, which has left the island powerless for over 3 months. This energy chokehold has postponed tens of thousands of surgeries and led to heated protests, including the burning of a Communist Party office in Moron. Back at home, the Department of Homeland Security shutdown is entering its 39th day as of March 25th, and it is safe to say that the situation is bordering on ridiculous. Senate leaders are racing to fund most agencies while leaving the immigration budget for a later debate. This impasse has forced over 100,000 employees to work for zero pay, leading to a spike in TSA callouts and security lines exceeding 3 hours in Houston and Atlanta. While Majority Leader John Thune proposes a framework to fund FEMA and the Coast Guard, Democrats are demanding reforms to ICE following a fatal shooting in Minneapolis. Meanwhile, President Trump has added more fuel to the fire by insisting on the Save America Act and deploying ICE officers to perform TSA duties. Finally, a major United Nations report titled Torture and Genocide was presented in Geneva by Francesca Albanese. The report asserts that Israel has institutionalized torture as state policy, affecting over 18,500 Palestinians, including 1,500 children. With nearly 100 deaths in custody and 4,000 people disappeared, Albanese called for international arrest warrants for officials like Itamar Ben-Gvir and Bezalel Smotrich, describing the prison system as a laboratory of calculated cruelty. This development is putting some serious weight on international legal cases at the ICC and ICJ as member states are pressured to reassess their military aid. That's all we have for now. Today's episode was made by Alexander King with Claude Opus 4.6, Gemini Pro 3.1, Gemini Flash 3, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.